Hi, I'm attorney Andrew Thompson from the Thompson Law Office in Carmel, Indiana. In this video, we're discussing winning legal strategies involving criminal defense of cases like DUI charges, defending against a charge of operating a motor vehicle under the influence of alcohol or driving under the influence of alcohol. Okay, in the state of Indiana, most folks watching this video know that the legal limit before you are considered statutorily impaired in your driving is 0.08. Okay, and as your blood alcohol content rises, the charge rises as well until it eventually becomes a felony for a certain level of blood alcohol content, depending on what other impairments you have or what your past record includes. What a lot of people don't recognize, a DUI charge, OWI charge, is very painful and difficult to go through in and of itself. You'll lose your license for a period of time. But what a lot of people don't realize is the long-term consequences that go along with it. So, and they typically, OWI and DUI cases are difficult, if not impossible, to bargain with a prosecutor in order to defer or dismiss the charges. Typically, the best bet is going to be to fight them outright if that's what you have to do. Okay? Now, if it's a first offense and the blood alcohol content is low enough to keep it at the misdemeanor level, then a plea bargain may be the best thing you can do, rather than facing a trial, which seems like you might not have a great probability of winning. However, we find all kinds of errors, omissions, mistakes, problems in assessing a person's blood alcohol content and impairment. We find police officers who don't accurately administer field sobriety tests. We find machines that are being used to test a person's blood alcohol levels that haven't been calibrated for periods of time that would indicate that they won't provide proper readings. And we find people that aren't properly trained in using those machines testing for blood alcohol levels. Even though it seems like a very straightforward, objective, and routine process, it really isn't. All the time we see differences between tests administered on the street and then back at the jailhouse, which vary by very significant numbers. So we might find somebody who tested a 0.15 in the field, but when they get back to the police station, they're tested again and they're 0.06. Okay? Very big difference, and something wrong is going on when that happens. And there are a number of ways that we handle these cases in order to manage them toward a successful conclusion, including acquittals before a jury at trial. If you need assistance in handling a charge of driving under the influence of alcohol, please call us at the Thompson Law Office, 317-564-4976, or find us on the web at www.thompsonlaw-in.com.